Welcome back to What Matters in North Carolina. The North Carolina Supreme Court with some significant decisions, a couple of them as a matter of fact, and here to break it all down and help us to understand is Elliot Engstrom. He's a lead counsel with the Civitas Institute Center for Law and Freedom. Welcome back, Elliot.
Hello, thanks for having me.
So first of all, we can talk about the North Carolina Supreme Court, and Justice Newby, I guess, wrote the decision for the majority, talking about the MAP Act, and declaring it unconstitutional.
Yes, so Justice Newby wrote the opinion for the majority. It was a unanimous decision, and the Supreme Court has declared that the North Carolina Department of Transportation's use of the MAP Act is unconstitutional in that they are taking land and not compensating landowners for that taking.
Now, this has always been a point of contention, the grabbing of land by government, whether it be a state or the federal government or even a city, having, I guess they call it eminent domain. Is that what we're at?
Yes.
And so saying that they need a property owner's land. And in this case, the Supreme Court, as you said that they were not compensating people appropriately or adequately. So in terms of history, can you kind of take us back to how this all got started? I think it was a case in Forsyth County.
Yeah, originally the General Assembly passed what we call the MAP Act, which is a law that allows the Department of Transportation to designate future interstate corridors. So they'll basically say, this strip right here, we're going to build an interstate here someday.
Right.
No idea when, but someday. And so a case was filed back, several years ago, actually, in Forsyth County, having to do with this northern loop that would go around north of Winston-Salem, right? And there were people in this corridor who said, man, the filing of this map has really affected my ability to use my property, my ability to sell my property. I'm not allowed to add a garage onto the side of my house. I'm not allowed to, build an extended driveway, all these kind of things. And they said, wow, that really feels like a taking.
Yeah.
And so they did something called, including the plaintiffs and attorney Matthew Bryant, who was the lead attorney in this case, did something called inverse condemnation, which is where you sue the government and you say, you are using your power of eminent domain to take my land. Even if you say you're not, you are.
Okay.
And so they did that, and originally they lost in Forsyth County because the Forsyth County Superior Court said this is just a use of the police power, so this is just fine. Police power, just because your property has decreased in value due to a use of the police power, that doesn't mean it's a taking. Because otherwise, all kinds of things would be taking all the time.
Right.
Because there's all around you all the time, the government is using its police power, saying, you got to have a handicap ramp into your building. You got to have a restroom, that kind of stuff.
Well, our guest is Elliot Engstrom. He's a lead counsel with the Center for Law and Freedom at the Civitas Institute. So the Supreme Court said that they were basically applying this power that they have to take land and compensate people. They were just not doing it appropriately, right?
Yes. So they said this is not a use of the police power. This is a cost control measure for the Department of Transportation. You are reducing how much money you have to pay if and when you ultimately buy these properties. And so, for example, you put someone, because they did buy some properties in the past for the corridor, and what would happen is they'd designate an interstate corridor, properties within the corridor, the value would decrease because they're within the designated corridor, and then DOT, when it purchases the property using eminent domain, it pays less. And that's textbook taking.
Yeah.
Right? And Justice Newby saw that. And by the way, any Justice Newby decision is worth reading.
Yeah.
Because you will learn all kinds of stuff. But particularly a Justice Newby decision about property rights, where he cites John Locke and talks about the rudimentary idea of property and what it is and what the elements of property are. I mean, this should be, I'm not going to say required reading, but it would be wise for any North Carolinian to read his decision.
Wow. Well, I'll have to make a note and check that out. He is an excellent justice on the Supreme Court, as you say. And so the other case had to do with cyberbullying. Now, how can a law that is designed to protect kids or anyone from being bullied online be unconstitutional?
Yeah, so there's several issues in this case, and this dealt with, as you said, whether whether a cyberbullying statute was unconstitutional. And the statute said you can't make certain postings on Facebook. Like you can't put out private or sexual information about a minor on Facebook. And there were several questions. One was, is that prohibiting conduct or is that prohibiting speech? Because if you're prohibiting speech, you're in the realm of First Amendment. If you're prohibiting conduct, then you're just in the realm of general police power.
Right.
Now, the Court of Appeals originally found that this law prohibited conduct, and therefore it's a lower barrier to rule it. There's a lower barrier for the law to survive. The Supreme Court, this is Justice Hudson, found that this law, in fact, does prohibit speech, and that the speech is content-based, which means that you're posting specific certain things. And that takes us to your original question. You're saying, how could a law that protects children be unconstitutional, right? Well, when you have a content-based restriction on speech, like here, where you say you can't post certain things on Facebook,
right,
or anywhere else, the question is, does that content-based speech restriction meet something called strict scrutiny? Because it has to satisfy strict scrutiny in order to survive. So that means, one, is there a compelling governmental interest behind the statute? And two, is the statute narrowly tailored to serve that compelling interest? And so all the way back around to the original question about children, actually everybody stipulated in this case, protecting children on the internet is absolutely a compelling governmental interest.
Yep.
So nobody's questioning that. The question is, was the statute narrowly tailored to that interest? And the court said no, it's not. Because it's too broad, there's too many things that could fall within the gamut of this statute. The statute has no requirement that anyone actually be hurt by what you post. And just that there'd be too much stuff that would fall within this statute for it to be upheld. And so the statute ultimately was ruled unconstitutional, and the person who was convicted under it is no longer guilty of a crime.
Well, that's why you're the attorney, Elliot, and I'm just the guy running his mouth here behind the microphone. Let me just see if I can make some sense of this. Could somebody's kid under this ruling now bully somebody else's kid online?
Okay, so bullying it's a difficult question, right? Because if what you're saying is, should someone be able to say mean things on the internet?
Right.
Under the U.S. Constitution, absolutely they should, right? They absolutely should be able to say mean things on the internet, things that are not nice, because otherwise you're outlawing speech based on its content. And one of the points that Justice Hudson makes is that people are going to say things we don't like. People are going to say really mean things. People are going to say really bad things.
But is there a line?
Oh, sure, there's a line. Absolutely, there's a line. There's something called fighting words, for example, where you're not allowed to induce violence, right? So if you say something that is meant to induce violence, then you can't do that. And so that applies to the internet just as much as it applies here. If it says, hey, everybody, let's go over to Jeremy's house and beat the crap out of him later, can't do that, right? But just saying, in this case, it was about sexually charged text messages. People were making fun of each other and saying mean things about each other because of sexually charged text messages. I don't like that people say that, but we live in a country with freedom of speech, and I think that there certainly is a line, but this statute is not right. It's far too broad. Okay.
Well, our guest is Elliot Engstrom, and he is the lead counsel with the Civitas Institute Center of Law and Freedom. So I just trying to wrap my brain around this, because it just seems like, and I agree. I mean, free speech is tantamount, but to have, 8 or 10 middle schoolers ganging up on, another middle schooler online, and because they may be overweight and just, posting how, calling them fatty or whatever, could be very traumatic to somebody who's in a developmental stage. And yet, because of freedom of speech, apparently that has to be allowed.
There's that element of it. There's the element of we don't want to outlaw speech unless we have to. So, and by the way, there might be a way they could rewrite the statute that would be narrow enough, right?
Okay.
That might exist. The other thing is, the statute doesn't apply to it applies to minors, right? So it applies to minors who say stuff about each other. And imagine 12-year-olds say really rotten, mean things about each other. Do we want to treat them all as criminals because of that. I mean, when I was in middle school, I could think back to things I said to people that I shouldn't have said that were bad. But do we want to use the criminal law to enforce that kind of stuff? You know, I mean, do we want to be putting people in jail and having them, you know, so yeah, I mean, when you have these cases of people being threatened to the point that they're committing suicide, that's one thing. And Justice Hudson even says in the decision, this is a blurry line.
Okay. Well, we're going to leave it right there. Elliot, thank you. Always available on a moment's notice. We wanted to hit these topics and appreciate all that you do for the Civitas Institute for the Center of Law and Freedom and for being our guest here today on What Matters in North Carolina.
Thanks for having me.